Good afternoon, everyone, and I'm really grateful to DSCI and NASSCOM for providing me this venue as well as the opportunity to talk to all of you. So, quite often when we're talking about privacy, we're only talking here about informational privacy. And when we are talking about informational privacy, quite often we are talking about the Data Protection Bill and its current avatar. And there have been at least 3 avatars we have seen much more recently. I thought it would be much more useful, tangible, as well as appropriate to the audience here for me to do a run through and to also highlight during this consultation process, which is right now ongoing till Jan 2nd, what are certain issues and what are potential areas of engagement on the Digital Personal Data Protection Bill. Now, before I step towards this, it's important to understand that the baseline for informational privacy is being set by the Justice K.S. Puttaswamy judgment, which was given in August in 2017 by the Supreme Court of India. I was one of the 200 lawyers involved in that case. And one of the clear things which came from the 600 pages which was there was the opinion of Justice Chandrachud. And if you ever go back and read that opinion, the last 3 pages probably, you will come to understand that the court is prescribing both a limitation on the government as well as a positive obligation on it. A limitation in the sense that what it cannot do, and a positive obligation as a clear direction to make a data protection law and to make this data protection law as per the principles under the Justice K.S. Puttaswamy judgment. So the baseline of comparison quite often is not what has changed between the different versions of the data protection bill, which we have been trying to create at least since 2010. It is the Justice K.S. Puttaswamy judgment itself. And for those who do not want to go through the 600 pages, I would urge them to go through the last 3 pages of Justice Chandrachud's opinion. Now, the roadmap for the data protection bill starts somewhere in 2010-2011 with the Department of Personnel and Planning making what was called the Privacy Bill. And this is very important for us to consider because the Privacy Bill, even though it was not put to public consultation and only versions of it came to public knowledge through leaks, it was essentially a much more broader legislative exercise. It dealt both with data protection as well as surveillance reform. And conceptually, these are 2 different things. The GDPR deals with data protection, and there are separate regulations in Europe with regard to surveillance. However, India has not had surveillance reform, and the slight bits of surveillance reform which have occurred through a 1996 judgment which is called the telephone tapping judgment. So we've never had a full statute for things such as surveillance oversight, parliamentary oversight, prior judicial sanction, etc., which is why in 2011, when the government was considering coming out with the law on informational privacy, it was dealing both with surveillance reform. These are conditions under which information is gathered with respect to a data principal without their knowledge, but also with regard to data protection, when knowledge is presumed with respect to a data principal and thereby they are put to notice. However, it did not succeed and it was withdrawn. Subsequent to that, what we see is MITI constitutes a committee of experts which is chaired by Justice Sri Krishna. And this version of the law, which is appended with the report, which is released after 2 years of deliberation, is referred to a joint parliamentary committee. The joint parliamentary committee suggests several amendments to it. However, this version of law is completely withdrawn from Parliament, and under the commitments made by the central government, it does put a new law to public consultation. And this is what is before us today. Prior to the extension, the Digital Personal Data Protection Bill, or the DPDPB, and this is quite a wordy thing to say, is now open for public consultation till Jan 2nd, 2023. So all the best for your winter vacations. So when we look at the application of the law and the first chapter, it retains the core conceptual foundations of the GDPR or Global Data Protection Statutes, which is consent. And how is consent effectuated? It is effectuated when you put a person to notice right? When they know what you are gathering about them, how will you use it, and with whom you will share it, right? So those features are also present within clause 6. And prior to that, in clause 4, what is interesting to note is that the application of the law is restricted to India, in a sense. So what becomes important to consider here is quite often the data offshoring which is taking place and the GDPR compliance which is taking place, which is governed by contract, will continue if this provision is maintained in its present form. There's also a huge question mark on adequacy, given that the law by itself, in terms of its application, does not extend to data which is generated and processed abroad, right? So, in a way, the law is limited to what data is processed within India by itself, is collected within India. Now, in terms of notice, if you look at notice, the two principal categories here are the data principal and the data fiduciary. The data principal is the individual, and the data principal is essentially not an artificial entity. It will be a natural person. And the data fiduciary is the entity which gathers the data. It can be a natural person, it can be a company, it can be an association. However, clause 6 requires data fiduciaries to merely notify the data principal the nature of the data they will be collecting and the purpose for which data will be processed. Unlike previous iterations of the bill, it does not require data fiduciaries to inform data principals about third-party sharing. Now, why is this important? Why are these details missing? So when we look at the present avatar of the data protection bill, it strikes us as something which is very simple. It's in 30 clauses, and you can read it within half an hour if you really have your coffee and you have it strong. But if you look at the Sri Krishna version, it takes you about 2 days to read it. It has all this detail present. So when you take away all that detail, quite often the anchoring legislative criteria which are present in a data protection statute or a regulation, like even the GDPR, which is written in simple English, is absent. So quite often this absence is coming at the cost of proper definition, which will be notified at a subsequent point in time by the central government, which under the business of allocation rules means the Ministry of Electronics and Information Technology, and this is at least 18 times. I'll come to this a little later, and what is the practical consequence, especially for businesses, given that's the composition of the group here. Now, consent also can be, it needs to be freely given, specific, informed. However, there is also a provision for deemed consent also, and this is also a departure from the GDPR. The GDPR essentially will be with respect to consent and certain exceptions which are there. They are not large categories under which there's deemed consent. And if you look at deemed consent a little much more closely, the categories appear to be fairly broad. For instance, the public interest category goes beyond Article 19(2). And this makes me go back to from where I started. I said the basis of a data protection bill is the Justice K.S. Puttaswamy judgment. So when you go beyond Article 19(2), which are the reasonable restrictions, will such a law satisfy the constitutional thresholds set by the right to privacy judgment? And if it does not, our experience quite often has been that as soon as a regulatory body is established, as soon as a law is passed, it is susceptible to constitutional challenge and for another 10 years of litigation in the courts. This has been the experience with respect to telecom regulation, financial market regulation, etc., etc., etc. Now, what are the general obligations of a data fiduciary? You should comply with the law, you should keep the data accurate, you should implement appropriate technical organizational measures, you should publish contact informations, etc., etc. And there's also the additional obligations of a significant data fiduciary. Now, what is important here to also consider is that when you read it, when you read this clause a little much more casually, you will say this will apply to big tech. This won't apply to us. But notice what does it say? The volume and sensitivity of personal data. It does not say high volume. It does not say high sensitivity. Hence, the value behind that is missing. And even if you say, Apar, you are just quarreling about this, right? Obviously, it will mean this in a natural construction. Come to G, which says such other factors as it may consider necessary. Now, such other factors are essentially notifications which can be made by the central government without any anchoring criteria again in the law, right? And the obligations for a significant data fiduciary then means increased compliance without determinacy, without bright line standards in the main anchoring legislative provision by itself. Now, in terms of clause 10, there are additional obligations in relation to processing of children's personal data. I know there has been some amount of controversy regarding this, given that many say that online services are availed by people who are between the ages of 16 to 18, and the age of majority should not be prescribed as the age of a child. However, at the same point in time, the age of majority as 18 is prescribed for a wide variety of legislations, which starts with the Indian Contract Act, which also is with regard to financial regulations, etc., etc. So one really will need to work around this if you want to drop it below 16 by itself. And quite often a way which has been found in foreign jurisdictions has been a specialized statute which is made for the protection of the privacy of children, in which there are additional compliances which define the child to in fact be below the ages of 18, but not have that kind of burden which is there for, let's say, differential obligations for people between 14 to 16 and people who are much younger. Now, what is really novel is the rights of the data principal also coming with duties of the data principal. As per me, and I think even if you do a comparative research of data protection laws globally, I don't think so there are laws which prescribe duties to individuals who are the beneficiaries of a data protection law. And I understand the legislative objective behind this. The legislative objective behind this is that there's so much cybercrime happening. There's so many cyber frauds. Hence, we need to ensure that they are the correct and complete details of every person who's the user of an online service is matched against their actual details which may be in their government issued identifications, right? However, if we think about it a little much more deeply, one of the core principles of a data protection law is called data minimization, which is that the least amount of data should be turned over which is necessary for performing the function of the data fiduciary for which the consent is taken. This will increase the amount of data, and I think will work out rather counterintuitively. But what's rather concerning is for a breach of the duties of a data principal by itself, which means any of us as individuals, there can be a penalty of 10,000 rupees which can be placed. And think about it a little much more reasonably in terms of the number of services we use and our differential standards of trust in trying out a service when it prompts us for our name, age, gender, and we do not provide it completely. It can lead to bad outcomes. Now, the transfer of personal data outside India is definitely a clause which does need to be appreciated, in part because it departs from the understanding under the Justice Sri Krishna test, which was forcing a kind of localization. I think removing it is good. It's much more accurate with global data flows. However, the basis of the exemption is again a government notification without anchoring criteria. Understand it's a geopolitical issue in terms of that kind of assessment. However, I think that can be prescribed also to ensure that when the data is offshored from India, it needs to have equivalent standards to ensure that our data is kept securely in another country abroad. In terms of the exemptions, I think clause 18.1 is quite similar to the Justice Sri Krishna version. It received a huge amount of critique. But what's really concerning is clause 18.2. And I want to take some time on 18.2 and 18.3. Now, 18.2 makes the exemptions a little much more broader. It says that any instrumentality of state can be exempt from under clause 18.4 with respect to data retention after the purpose is fulfilled. So what is the instrumentality of the state? It is also the Municipal Corporation of Delhi, which means that if it takes over data from any person and performs the function for which the data has been taken, it can continue to retain it indefinitely. And exemption 18.3 is also very concerning. It is exemption for a data fiduciary or a class of data fiduciaries with regard to the volume and the nature of personal data. Again, that's a very broad criteria. It's not well defined. And how will it play out? Data fiduciaries does not only mean state entities, it can mean individual private companies. It can mean class of private companies. Who is the body which will give this exemption? It will not be a regulatory body. It will be a ministerial office by itself. The Data Protection Board, which is a statutory body which is being established under this law, is not similar to a data protection authority which was under the Sri Krishna draft. The Sri Krishna draft was establishing a regulatory body which could also make regulations, standard setting, practice guidances. How does it apply to MSMEs? How does it apply to specific industry sectors? For instance, mining. However, these powers are not there in the law with respect to a data protection board. The data protection board's principal power is to adjudicate complaints which are made by data principals against data fiduciaries by itself, and such other functions which may be prescribed by the central government. Its staffing, its sittings, etc., as much as it plays a quasi-judicial function, will all be determined by the central government. It will not have a physical office. It will conduct its functioning through a techno-legal measure, which means that it won't have allocation of land, financial resources, etc., which is usually there for regulatory bodies, as financial memorandums are there in proposed bills usually. Now, review and appeals also, which are provided under this law, will oust the jurisdiction of the civil courts, which means it will be stuck for a long period of time. And I think the first few penalties which are levied by this body, because of the faults which are there with respect to its constitution, the absence of natural justice, will result in the same kind of outcomes we have seen with the Competition Commission, with SEBI, with TDSAT, etc., etc. So I don't think so there's a fear of financial penalty flowing quite soon, but that also then prevents and gridlocks the application of the law. You exist in a larger environment of uncertainty that undermines user trust in terms of sharing of personal data. So this was what I was saying with respect to section 16, which are the duties placed on data principals. And finally, with respect to amendments, it will remove section 43A of the IT Act. It will also amend the Right to Information Act. So there's been some concern. It will result in the hindrance of section 81J, and under certain conditions, information which is shared, which builds accountability, for especially for people who seek pensions and social security benefits. Because the law there is fairly well settled that privacy is a subsidiary condition to the larger public interest which is satisfied from public disclosure. But as per me, the main challenge with this law is a little much more structural. It is that the Data Protection Board does not have the power to make regulations. It's not an independent regulatory authority. And some people say that's a good thing. In my view, it's not. As much as our experience with regulatory bodies may not have been very healthy in India, it's been imperfect, it's still been better, I would believe, with dealing with a central ministry with respect to practice guidances, rules and regulations, which will be need to be done at a very rapid pace. And I'm making an argument of good faith here. For the past 4 years, the budgetary allocations of the Ministry of Electronics and Information Technology have been stagnant as much as digitization has really exploded in India, both in terms of teleconnectivity as well as the range of activities. The own policy documents which have been placed before the public by the Ministry of Electronics and IT sometimes do inspire confidence, but also inspire a certain degree of criticism. So, what would be better would be a regulatory authority rather than centralization of control in a government ministry by itself. So with that, thank you so much, and I really thank the SCI for this opportunity to present these views on the upcoming data protection bill. That is a bad place to start with respect to a data protection statute. And secondly, I think that the institutional process, which was followed for about 3.5 years, a JPC actually sat, gave recommendations. I think architecturally, the main choices within it need to be followed. They do they do reflect actual public consultations, industry inputs, and it's not like a person like me who's been advocating for stronger privacy law was very happy with that law either, because it had wide exemptions. But I think it laid greater certainty. The enforcement mechanism, I think so, was much more clearer, which is better for business, which is better for individuals. I think it's better for the larger ecosystem. What we are having here is a law which we think is very simple, which will be very flexible, which will maybe may not be enforceable, but I think it gives a high amount of power to determine the path of enforcement at a future stage. So that flexibility may come with a cost at a later point in time. And I think it is not very conducive for business, for the business environment. I think it's not about the law going away from the rights of the individual. I think privacy is a multi-sided conversation, but it does start with the individual. That they are the primary beneficiaries of the law. What I think this law does is possibly best put by in a quote by Yes Minister, right? The Official Secrets Act is not to protect secrets, it's to protect officials. I'll just leave it at that.
Just a supplementary question. What is the intent to build this bill? Because you started the outset like subjectivity is there. So we all know whom the subjectivity supports. Subjectivity always supports the mighty and the powerful. And in that case, it can be any industry which is violating it, any sector which is violating it, and the government which is actually across the globe the biggest violator of privacy. And looking at the intent, it doesn't comply with the global privacy bills also. So what is the intent with which this bill is brought in now?
I think the intent to bring this bill is to bring a certain degree of certainty to regulation with respect to the technology industries. This is one in a larger landscape. I don't think so. A vision document has been put forward formally by the Ministry of Electronics and IT. But if you look at the European Commission, it has placed a digital vision to place based on pre-existing statutes and new statutes. What it calls is digitization within European values. Okay, so they say that Digital Markets Act, Digital Services Act, after the GDPR, after our competition law, is what we are the pieces we need to build a digital society around the things which we want our society to progress towards. So I think similarly with the telecom bill, with the data protection bill, and what maybe the Digital India bill or act, and one does not know its broader contours. One knows it through the press and ministerial interactions, but not through an official path forward. I think it's that degree of, I think so, of desire by government to lay down the regulations which have not been able, it's not been able to do till now. So I think that's the broader objective by itself, to make the laws. Now, we may question the qualitative value of those laws, and I do question them. And I do not think that the way they are being done satisfy those promises. There's also some degree of improvement, and I think it comes from industry quarters as per their official statements with regard to the telecom bill as well, right? So I think what's needed now is a larger roadmap in which we can place not only the privacy judgment, but larger digitization in a much more ordered way and deal with the choices we have to make in that sense. I would agree that governments all over the world, not only in India, are the biggest violators of privacy, but we also need to consider at the same point in time is that this is a new conversation, and nudge them towards that right intent which is there. It's not present, I think so, in terms of its articulation under the present law, but that's why there's a consultation, and I hope till Jan 2nd, more people like you can send in those views.
One quick question.
Leaked at any certain point in time, and it's leading to a very high rise in cyber crimes. So it's actually hurting business, it's hurting the government, because it's undermining and eating away our trust in digital services. So I think that's a very tangible manifestation, but it's a little short-sighted to just say we'll improve security, we'll build these 13 feet high, 5 feet wide walls, and that will keep our data safe, or even implement encryption, etc. Because the starting point quite often is that what is the data being collected? Is it really necessary? does it need to be retained by itself under a mandatory direction for data retention? And doesn't that increase cost for businesses by itself as well as put the end data principle at risk?
So should it be broader just as safeguard, or putting security safeguard or privacy safeguard? Probably it should just be left as safeguard.
In what sense, if you can explain?
So the regulation clause 9.4 says that the businesses have to ensure the data breach
Yes,
does not happen,
yes, yes.
and they have to put necessary security safeguards in place.
Yes.
Which is very limiting because breaches happen beyond security
Yes,
safeguard.
yes.
And so probably they would have left it as just safeguard, or they should have put privacy safeguards. Why security safeguards?
That makes a lot of sense, and I think that's a great suggestion. I think that's something I have not looked at. That's great you spotted it.
Thank you.
Hi, Parth. Thank you so much. I think it's a welcome move in terms of the data protection bill. The only thing that I have in mind was with regards to the offline data. Maybe we talk about digitization, internet, everything. We don't talk about offline data that is.
However, quite often the point of data collection is through physical forms. That's our experience in day-to-day life, and quite often the chana is served with somebody's customer acquisition form. We know that. Okay. Now, secondly, in terms of the impact and what it will be, I think that will be left to specific regulations which will be brought about. I think something which may impact telemarketers more than anything is an open consultation by the Telecom Regulatory Authority of India, which is happening right now with respect to caller name identification and how it will approach that. So I think that will have a wider impact. Thanks. Correct. Yes, that is correct. And again, I mean this seriously. I don't mean this as things which uh, to save time or to stave off questions. I mean this very sincerely. There's a consultation process right now. It's on MyGov, and these kind of suggestions which go from the industry sectors, especially with respect to specific examples, sometimes are found to be very persuasive by bureaucrats and policymakers. So I would encourage you to do it, okay, and eat away a little bit into your family time over the vacations. Thank you so much.